Have you ever found something so offensive that even though you said you would not go there anymore, you can't help but think about it, to analyze it, to look at it? A couple of days ago, OKJ was scrolling through the news feed, and I saw where the hussy was filing motions because she's going to go pro se and represent herself. Now, I must confess that I did not believe that she was going to go there. Okay, I didn't think she really would do it. I thought this was all just, her just trying to puff up and let that grandiose and narcissistic behavior take hold of her for a little bit. I mean, folks, let's get for real. Sarah Boone got in way over her head, and she knew that she had to have help. You got this other fella. What was his name? Somebody put it in the comments. This dude who represented himself that everybody said was a big circus. What was his name? Come on, somebody put it in the comments. Oh, I can't even remember dude's name. But anyway, OKJ did not watch. Was it Daryl Brooks? That's what it was. Daryl Brooks. That's who it was. He represented himself, and everybody was just watching that with bated breath, getting a kick out of that shit. Folks, if Lori Hussey Daybell represents herself, this is going to be something that OKJ is not going to be able to look away from. I'm just not. So I'm here today to talk to y'all about the questions that I have in all of this. And I'm going to share a little justice through understanding with you. As I tell you now, I will absolutely move forward on this. I have to. I thought this damn wench would get some legal representation, and it would just go down. It'd be just a body slam legally for her, and then she'd go back to Pocatello. But think about it. This woman actually thinks she's going to do whatever. I don't know if she thinks she's going to be successful, y'all. This really does have to do, in my opinion, with a demon in the damn corner. She is in the corner, and demons are so damn smart, aren't they? I mean, some of y'all would say, well, KJ, it's got to be her mental illness, her grandiose thinking, her narcissism. She wants to be in the spotlight, and y'all, I've poked fun at this damn wench. Y'all have seen the skits. I thought that she would get her legal representation, and during that time, I would make a few people smile during her trial. Release something here and there of Lori and maybe Veronica, and just have a good time with it, because y'all, this shit's heavy. But here are my questions, okay? Why does Lori want to represent herself? That is a simple question. Why does she want to represent herself? This woman has done nothing to respect authority at all, and yet she wants to use the judicial process to basically make herself have a little power in the whole situation. She wants to use man's law that she's done nothing but flip her nose to the whole damn time. Isn't that just what evil does? On one hand, I gotta bleed the dragon, and on the other hand, I'm gonna use it to my benefit. So what is her state of mind in that she wants to represent herself? Well, we had some comments when this live stream announcement, and some of y'all think it's just a way to get some power. Some of y'all think that it's just a way for her to, because she already knows her ass is going to Pocatello for the rest of her days, and she doesn't care. But I'll tell you what I think. I think this woman has no respect at all for the fact that Charles Vallow was a good man, Brandon Boudreaux was a good man. She wants to shit all over anyone and everyone on her way out the door of Arizona back to that damn Pocatello prison. Another question. How was she able, and we're going to go over her little motion request there. How was she able to put together a discovery request with citations, legal citations, without legal help? Somebody's helping her. I don't know if Maricopa County Jail over there's got a law library or somebody in there that can help this woman. But she put it together. It was handwritten. But she cited a bunch of legal precedent and this and that, the 5th, 6th, 7th, 8th amendments and blah, blah, blah. The common sense of any of it, y'all, is these other attorneys that aren't going to be her attorneys are helping her in some way. She had to have asked, now, where do I start? Where do I start? And really, what if it isn't that? What if it's just her frame of thinking? And when we go over this motion, maybe OKJ looks at it a certain way, like, wow, look where her mind's at, right? Another question that is tied to what I just talked about is why? Why these particular requests in her motions? We'll talk about that, but just bear with me. Let me get through it. We're going to learn I've learned some stuff. You might even be able to teach me something in the comments, but let's just see what we can put together. Another thing, will her crimes come in on with 404B and C? And I'll explain that. The crimes that she committed in Idaho. Or will they be irrelevant? Because what she did in Arizona was before she went to Idaho. It made sense in Idaho to do 404B, which actually 404B, the pattern they showed there, it wasn't for her character, but it was to show a pattern of criminality, was before what she was being tried for in Idaho. Now this is reversed now. Can 404B and C come in? We will discuss that. And really, how about this, y'all? Try this on for size. What about Kobe's recorded phone call with Lori, where she blames Tylee for everything? Will Tylee even be able to be in this? I can tell you right now, Tylee will be in this, because you know what's going to come front and center? Those police interviews with Lori, Alex, and who else? Tylee. And when those recordings get played in Arizona, and Tylee's gets played because it's relevant about what happened in that house, that will open the door for the 404B and possibly C to come in, because she's being shown to the jury. Tylee Ryan is being shown to the jury. And make no mistake, Charles Vallow will be avenged. He's the one, if the police would have listened to him in the first damn place, JJ and Tylee and Tammy would still be here. And really, what about her defense? She's not a defense attorney, but she's going to represent herself. She's got to have a defense, right? What is that defense going to culminate around? What is her questions to the witnesses going to culminate around in terms of her defense? Is it going to be Alex did it because Charles attacked us and all that? Just the same bullshit story that they came up with in the first place? And again, Tylee's police interview after the murder of Charles Vallow, and yes, he was murdered, that is going to be pivotal. It is going to be pivotal. It's very interesting, is it not, that what takes Lori down and has taken Lori down in Idaho was because of Charles Vallow, and now it will be taking Lori down in Arizona because of Tylee Ryan. You better believe it. How will Lori take it all the way, y'all? Take it through the whole trial, just like this Daryl Brooks guy. Is she really going to go there? She's got 6 months. Her trial's in June. She's already starting to file her motions, and make no mistake, y'all, the state of Arizona is going to kick her ass because they're going to have to respond to that motion of her, what she wants. And we'll go over here in a minute. So how will she take it all the way? How will she be able to do it? You know how she's going to be able to do it? Do you think that damn hooker is any less smart than Daryl Brooks or anyone else that's had that were pro se? She's going to study, y'all. I kidded around in skits about her. Oh, I've done my homework. I'm sitting by my cot. I got all my papers laid out on the cot, and I'm sitting on the floor, Indian style. Y'all, make no mistake. She is making this her business. She's using her own disgusting, evil, mental illness crap. That's what she's going to do. And ultimately, y'all, this is the big kicker right here. How will the jury react to seeing her do this? It is so pathetic that she obviously doesn't care one way or the other. Or she's so blinded by her evilness that she's seeing that she would do a better job than someone who can actually protect her, which isn't a defense attorney. Is this a stall tactic? And someone say, well, KJ, how could this be a stall tactic? She probably understands that she's got to go. Maybe she hates it in Arizona, wants to go back to Pocatello where she can start her, her little programs there in the woman's Pocatello prison. She wants to get settled in. She wants to get nestled into her new home for the rest of her freaking life. She will put on a show till it gets so hard on her, y'all. Sarah Boone, she gave it up right up front. She understood, as a drunk-ass woman as that was, she understood that it was way over her head. She's going to put on a show till it gets too hard, and then what's going to happen? She's going to say, I can't do this anymore, and by Arizona law, they'll stop it. That's when her defense attorneys will take over. She can stop the trial at any time and say, oh, it's just too hard for me. She can do any of that. That's Arizona law for you. Now, when I saw this a couple of days ago, I got 2 news sources. Of course, Justin Lum, he's on top of it all. And then there was another outlet in Arizona, and I apologize, I don't have it written in here, but they both said, for instance, a motion to order Maricopa Sheriff's Department their records regarding her records and communications between the agencies. And then in another news article, it said in one pro se motion, she requests that the state of Arizona produce discovery of what? Of extradition. What the hell does that have to do with whether or not she murdered Charles Vallow? The discovery of extradition, asking for records from various agencies from 2019 to 2024. Okay, so what she's asking for is really more about how the police were operating, because in her motion, she's talking about all communications and all this and that. She either somebody's helping her or she's got it in her mind that it's going to show that they didn't really arrest her or do anything to her or Alex. Y'all, this is going to come back to bite Madison County there. That's what's going to happen. But it's not going to get her off the hook. The bottom line is that is an opinion. And maybe it's just this cut and paste stuff that are these other attorneys are saying, well, you know what, Lori, if you're going to get started, you need to start getting this stuff. But what it doesn't get brought out in these news headlines is what Mark McGarry was talking about as well, and that about this motion where in the motion she's talking about things being privileged, like her mental health evaluations and things of that sort. Obviously, she doesn't want everyone to know how much of a kooky woman she is. She doesn't want anyone to know. She's been ruled competent legally. We know the standard there is they just got to be able to understand stuff. Well, here's the bottom line on that. She must think she understands it because she's trying to go pro se about it. So now I'm going to look at this motion that she hand wrote. And what's interesting right off the bat is it's stamped by the clerk of the Superior Court there on December the 16th, but her motion was on the 12th. So that's 4 days before it was stamped with the clerk's office. She's put this 2-page thing together. So it kind of shows you, and we've talked about the responsibilities of clerks and all of this, whether it was through Idaho or whether it was talking about Alex Murdaugh or whatever. These clerks have a very hard job. But specifically in Idaho, there was this whole damn thing about a certain woman who felt like the clerk's office wasn't doing their job when she was filing stuff to insert herself and all this crap. Y'all know who I'm talking about. I'm not even going to say her name. The bottom line is these clerks work hard, and for 4 days, it took only 4 days to be able to get that filed once she turned that in. It could have been she dated it the 12th, and then it took a couple of days to get to them, or it could have gotten to them on the 12th, and it took them a few days to stamp it and put it in the file. But either way it goes, that's pretty fast. And y'all are going to have to excuse me because this woman, she does not have good handwriting, okay? She's got chicken scratch. You know, that's just an opinion. I mean, who knows? Maybe my handwriting's bad, but I think I could make it more legible. But I'm going to do my best to read it. So please forgive me if I can't see that there's a couple of words in here that I just can't read, but here it is, y'all. The defendant, Lori Daybell, proper. And proper means that's what she wants to be called. But what's interesting about it is the legal documents from the state and from Arizona there says Lori Vallow. But she's going to say that's the proper way. She can have her nasty ass last name. She's got her husband on death row. I hope he enjoys his time on death row. Respectfully request that Maricopa County Sheriff's Office be ordered to produce the following items to the Daybell defense team and to the defendant. Now, let's stop there. Why isn't it the Daybell defense team, period? Why is it two separate things? To the Daybell defense team and to the defendant. There is the clue right there. She's got people helping her. Now, she can write all this stuff out and make people think that she's on top of it. She's the one. But the bottom line is there is a Daybell defense team, and these people are freaking idiots for helping her. That's what I'm talking about. All warrants, all summons, all requests, all correspondence between MCSO, MCAO, and all other agencies, any and all, if the defendant's requests, general inmate, ILS, grievances, GTL, and mailroom requests. Why does she need all this? Has she had some kind of mailroom request there? Or is this the law enforcement or the district attorney's office asking for requests through the mailroom to get copies of whatever, you know? Is she writing letters, that damn asshole? Is she asking Janice for more money on her canteen? What at the hell does the mailroom have to do with anything? The defendant has chosen to enforce. Now, this is the part I didn't understand about these news articles. I never saw, and I looked. They talked about the other stuff, but they didn't really go into the privilege aspect, which really is telling. Privileged communications and confidentiality. Psychotherapist, patient, psychologist, patient privilege under Rule 501 of the Federal Rules of Evidence. ORS 40-230, Rule 5042. Patient has the privilege to refuse disclosure and to prevent any other person from discussing confidential communications made for the purpose of diagnosis and treatment of the patient's mental or emotional condition. Therefore, the defendant will deny my person, agency, or others from obtaining MCSO medical and medical health records. Any unauthorized access or request should be denied. Now, I guess really, I mean, maybe this is her way of saying, I don't want anybody to know that I'm a freaking evil-ass mental case. I don't want anyone to know that I have this diagnosis. I don't want anyone to know. Well, folks, how many criminal trials have they brought in that type of information unless the defense opened the door to it? Now maybe in a penalty phase or something after they've been convicted. Oh, well, she suffered from, narcissistic religiosity crap. She couldn't help herself. They bring somebody in to explain away this woman's evilness. But she absolutely does not want anyone to know that she is a fruitcake, that she is a freaking demon. And then she says this request is made pursuant to the 5th, 6th, 8th, and 14th Amendments of the United States Constitution. And then she starts listing out different cases and the case law about it and everything. And again, who has been helping this woman? Because if nobody is helping her and she got her a law library book, or she's figured it out or whatever. Maybe the demon's in there going, Lori, this is what you put in it, whatever. If she did this all by herself, could you imagine the state's response to these motions, or the judge looking at this? Things have to be done a certain way, y'all. And it's obvious that either somebody helped her with this, or after she wrote it out, they looked it over and said, yes, Lori, this will be fine. The defendant is requesting that the court order the Maricopa County Sheriff to produce the defendant's conduct call logs, correspondence to and from, what was that? I can't read that word. Correspondence to and from attorneys, officials, MCAO, and all others, all warrants, subpoenas, and court orders to which the MCSO was requested to provide to others who obtain the above. All requests done electronically. B, the defendant, ILS, MCSO, MCAR, agency officials, and others, unauthorized and non-consent of the defendant. It is requested of the court to provide an order allowing the Daybell defense team access to the vital discovery listed above. Okay, so there you go. If you want to look at it in a nutshell, first of all, she wants everything that had anything to do all the way back to 2019 of any kind of extradition or correspondence or anything like that. Then she also wants any of her time in Arizona. She wants all conduct, call logs. She wants to know all this. And here's the ticker. What she lists in all of this, it's obvious that the state hasn't given her these things, or she would not be asking for them. So just to kind of explain basically what it all comes down to is the rules for criminal cases in Arizona for self-represented litigants, also known as pro se litigants. Compliance. Pro se litigants must follow the same procedural and substantive law requirements as represented litigants. They have to do it exactly the way it's supposed to be done. Filings. Pro se litigants are encouraged to file electronically, but it's not required. Obviously, she hand wrote it and had it filed. Behavior. Pro se litigants should dress appropriately, wait their turn to speak, and treat others with respect. They should also be honest with the judge and not lie or hide things, okay? So, y'all, I don't know about you, but this is going to be a sticking point for the damn hussy. She's living in a self-induced delusion, and that's not mental, that's just her evilness, where she's going to see her narrative the way she's seeing it, and when she starts talking that bullshit in front of the judge, that's not going to be good for her, because she has to be honest. Complaints. Complaints must be double-spaced on 8.5 inch by 11 inch paper, typed in a font no smaller than 13 point. Y'all, this is Arizona law. It's procedure. Or written legibly with ink. And yeah, she wrote it in ink and it's legible, so she was able to file it. They must include a caption, a short statement of the claim, a demand for relief, and a signature block. And she has all of that. Again, I don't think this woman is working by herself. She can shit in one hand and hope in another that anybody thinks she's doing all this on her own. She's not. She's getting help from someone. Assistance. Judges may provide information about the proceeding, help make legal concepts understandable to Lori, and explain the basis for the ruling. They may also refer Lori to resources to help prepare their case, but also in Arizona law, she cannot speak directly to the judge. She can't, and she wouldn't anyway. He wouldn't allow it. So she's going to have to, in all of her motions, I am very, very interested to see what's going to happen in a motion hearing on this stuff. Or whether they'll even have a motion hearing, whether the state will just say, well, the stuff she's asked for, we can go ahead and we don't have to have a hearing about it. Or they might have a response where they're shooting her down so she can really feel, not just feel the hair on Chad's balls when she was with him, but she gets to feel the judicial process and really how she does not stand a chance between herself being the freaking pro se and the state of Arizona. Discovery in a criminal trial is the process, y'all, of gathering and sharing evidence between the prosecution and the defense attorneys, and we already know this. But let me tell you this, y'all. It begins when law enforcement starts investigating and continues until just before the trial. So there could still be stuff that the prosecution still gets through investigation. It's not likely, but it could happen. And she would have to be able to be told about it. Then she would have to file something. The discovery process helps prevent surprises at trial by ensuring that both sides have access to the evidence. Well, I'll tell you what, y'all. That is a true statement. There shouldn't be no surprises at a trial. But I'll tell you, y'all, that damn hussy could say something in open court in front of those jurors that was not anything that was in discovery or anything like that could really piss the prosecution off, and we could get a mistrial. Just like that. Just like that. It could happen. Not that it's going to happen. I'm just saying that if this woman wants to present herself in front of a jury and be pro se and talk about, the way, because, you know, in terms of lawyers there, the prosecution and defense, what they say is not evidence, right? It's only from the witness stand. It's through exhibits. You know what I'm saying? But if she gets out there and somehow, like, for instance, in her trials in Idaho, her trial in Idaho there, she laughed, she bounced up and down, she did all these things. If she absolutely starts that stuff, y'all, oh, them jury members are going to be seething. I mean, what is she going to have the requisite demeanor to be calm like a defense attorney would be? I mean, y'all remember when John Pryor was up there and that real estate guy got up there and he says, you own it. Tell me about the property. And I mean, it came out of nowhere and everybody was just flat blasted, right? The bottom line is there's going to be one thing after another that she's going to exhibit because, y'all, she's sick. And I'm not talking about just mentally sick. She is a demon-possessed woman who will do anything and everything, not only to soil good people's names and shit all over a process, a judicial process that Charles Vallow and Brandon Boudreaux deserve. They deserve a good, robust prosecution of this hussy. But here she is. She's going to come in there and she's probably going to do all kinds of things, y'all. All kinds of things. Before, obviously, y'all, this is my opinion, she'll give up. She'll go through it a while. She'll get her point across. And then she'll be like, oh, I can't do this anymore. I can see the writing on the wall. The jury members hate me. They keep looking at me because I'm bouncing around in the room. You know, my chest is going up and down. I want everybody to see it. This woman is a nut, y'all. We're talking about Lori's got to grasp. I mean, again, I don't know who the hell this defense team is, this Daybell defense team. We're talking about depositions, possibly. We're talking about interrogatories, which interrogatories are written questions, also known as ROGs, that must be answered under oath by the opposing party before the trial. Those things can happen. Could you imagine Lori wanting to depose somebody or getting, sending, I could see that before I could see her. I mean, y'all, she's going to get money for her representation. How she uses it, I don't know. Request for production, like she's done in this one. A request to the opposing party to produce relevant documents, such as emails, medical records, or accident reports of such, She's absolutely going down that road. Request for admissions. A written request to the opposing party to admit or deny certain facts. These are usually what people would call stipulations. I guarantee you the state of Arizona ain't gonna freaking damn stipulate to shit unless it's something that's gonna put the nail in her coffin. Discovery may involve the existence, description, nature, custody, condition, and location of books, documents, electronically stored information or other tangible things, as well as the identity of persons or persons having knowledge of something that is discoverable. Even if something is arguably not discoverable, it could be a part of a motion there. And this could work the other way as well through the state. The state could ask for these things. Well, I've got some tips for the hussy, all right? The first tip I've got for that damn hooker is she needs to inform herself on the relevant facts. The relevant facts show that this woman's a freaking serial killer murderer. And 404B and possibly C's gonna ram so far up her behind, she ain't gonna be able to sit down for a year. Another tip for Lori. She's gonna have to tell the truth, y'all, and she's not going to do that. You can tell this woman tell the truth a million freaking times, but she only knows one truth. And that truth is that she's done nothing wrong. This is persecution of the goddess. She's just passing through this life. She's got another life on the other side. Chad and her are going to be walking the streets of Jerusalem in her new world order or whatever the hell. Lori needs to take the tip that Lori Hussey Daybell, the evidence in this Arizona trial is going to be used against that hooker to the fullest extent. So if she wants to take my tips and thumb her nose at those tips because she sure as hell ain't going to tell the truth, the bottom line is she'll obviously say, can I see the evidence against me? And the answer to that is navigating the complexities of a criminal trial can be daunting for any defendant. Among the many facets of this process, understanding when and how you can review the evidence against you is crucial. It's a fundamental right. You are always entitled to examine the evidence the prosecution plans to use in your case. And just think about it like this. Since she's been in Arizona, she's had those past attorneys. As soon as those attorneys wanted her competency and all evaluated, which was a smart thing for any freaking defense attorney, she shut them down. She didn't want anyone to even question her sanity. Well, I'll tell you what, this woman is very sane. This woman is competent. She's just an evil, diabolical woman who is a serial killer who will stop at nothing to get herself out of trouble. And if she thinks, she might even think that if somehow, some way, that she could get off the hook, there'll be reasonable doubt that this was all Alex and she really didn't do nothing. There was no evidence at all that she killed Charles or had anything to do with the attempt on Brandon Boudreaux's life. Then that's going to make her feel better about the fact that she was adjudicated in Idaho a freaking serial killer of children and a precious woman like Tammy Daybell. What must be provided to the defense during discovery? And this has been an ongoing process, y'all. This has been going on. This isn't, she's just now filed this motion and she's going to start getting discovery. The discovery's already started coming in because she had attorneys before she decided that she was better than them all. In a criminal prosecution, discovery can include a wide range of items that are often crucial for her defense, such as all the hard evidence in the case, such as physical evidence, exculpatory evidence that could be favorable to the defense, witness statements and depositions from the police. She's had all that. She has gotten the discovery. She's got the discovery, y'all, from the state. These are things that she in her motion have not gotten from them. Whether she took some legal advice from these stupid attorneys that are standing off in the background, they should walk right out the damn door and not help her one damn bit. If she doesn't think these defense attorneys can do their job and that she can do a better job at it, then they need to say bye-bye. Go do your thing, Lori. But I want to tackle this one question about whether or not in the discovery, whether there can be the prior acts, not prior act, but a pattern there. In other words, what she's been convicted of in Idaho, what went on in Idaho, and whether that can be something that can be brought in under 404B, looking back instead of looking forward. Because remember, what happened to Charles and what happened to Brandon was before the murders in Idaho. So that is something I'm not clear with. But I got to looking at the 404 Arizona Rules of Evidence. It says character evidence is not admissible, all right, to prove conduct. Let me say that again. Character evidence is not admissible to prove conduct. But guess what, y'all? There are exceptions. And you know what those exceptions are? Under Arizona Rules of Evidence 404, and I'll read the A and the B and the C. The exceptions are other crimes, wrongs, or acts, okay? Now, they don't tell you what that means. Acts is a general term, right? So, other crimes, okay? Let's not even look at Idaho. Did Lori commit any acts or any criminality before Charles and Brandon, before all that? Was there anything there that can come in? And again, can these crimes or wrongs or acts that she was adjudicated guilty of in Idaho, can those come in? Well, let's look. In the A section, character evidence generally. Evidence of a person's character or a trait of character is not admissible for the purpose of proving action, like the action of the charges against Lori for Charles and Brandon Boudreaux, okay? On a particular occasion, except, all right, number one, the character of the accused, evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the same, or evidence of the aberrant sexual propensity of the accused or or a civil defendant. Now, what that means is that this can come in if Lori, in her defense of herself, okay, is trying to bring in this trait of, I'm a good woman, I was a good mother, I was a good wife to Charles, and all of this and that. When that shit starts to happen, she's opening the door that the state can rebut her saying through her defense that she was a good wife to Charles, or that she had a great relationship with Brandon Boudreaux through her niece, Melanie Boudreaux, right? Number two, the character of the victim. Now just remember, y'all, evidence of a person's character or a trait character is not admissible for the purpose of proving an action of the attempted murder or murder, except the character of the victim. Now, okay, the victim. Who are the victims? Charles and Brandon, right? Evidence of a pertinent trait of character of the victim of the crime offered by the accused, offered by Lori. If Lori offers a trait, if she's going to let the jury hear what she thinks of Charles Vallow and Brandon Boudreaux, or by the prosecution to rebut the same, in other words, if she's going to bring it, the state, she's opened the door, now 404 can come in. The state can rebut it by saying that Lori was screwing that nasty ass Chad Daybell behind Charles's back, and how Lori was calling Brandon gay to get Melanie, his wife, away from him, and all this, you know. It says, or evidence of a character trait of peacefulness of the victim offered by the prosecution in a homicide case to rebut evidence that the victim was the first aggressor. This is important because Lori is going to say that Charles was the aggressor. And the state is going to have, she's got to say that, right? What else is she going to say? Is she going to say, she can't say anything. She's going to have to say through her defense that Charles came in there and got mad as hell, and Tylee had the bat and Charles was beating on everybody and all this stupid lying. The state is going to have to come back and they're going to have to rebut it by saying Charles Vallow was not the aggressor at all. And character of the witness, evidence of the character of a witness as provided in Rules 607, 608, and 609. The character of a witness can be an exception to the evidence of a person's character or a trait of character, i.e. Lori Hussey there. We're going to find out. We're going to find out who the witnesses are going to be. We're going to find out if Lori is going to testify. Do you put it past Lori Daybell at all to want to represent herself and also testify? Y'all, this woman's a nut. But that's the A section. 404A, and now we get to 404B, which was successful in Idaho. Other crimes, wrongs, or acts. Number 1, prohibited uses, except as provided by 404C, which we hadn't got to yet. Evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therein. 404B evidence cannot be used to make it look like Lori is what she really is. We all know she is. It cannot be used as a way to say that look how she was acting. And so because she was acting this way, this is her character. It cannot be used that way. And remember, y'all, when it comes to this, and if it does get ironed out that 404A, B, or C gets used in Arizona, there'll be jury instructions that will explain to the jurors how it's to be used. But there are permitted uses of 404B. This evidence may, however, be admissible for other purposes, such as proof of motive. Do y'all think the damn hooker had a motive to murder Charles Vallow? I say she had a million reasons to want to murder Charles Vallow. You can be damn sure of that. Did she have a motive to want to murder Brandon Boudreaux? There was money involved in that as well. Looks like a pretty damn good motive to me, but even if you didn't want to look at it that way, which we all know, it was all about sex, money, and power, right? The bottom line is that she didn't want to have to go through a divorce with Charles. She wanted to be able to have that little itty bitty gherkin. Oh, disgusting, slimy ass woman that she is. So it's a motive, opportunity. Well, the woman was there. The woman was in the freaking room. And some people on this channel say that she helped Alex. She pulled the trigger on him and just let Alex take the rap. Or maybe Alex shot him and then Lori walked up to him, grabbed the gun from Alex and shot him. Makes no difference according to Arizona law. The woman murdered Charles Vallow. So yes, she had the opportunity. And the intent? What was the intent? I'll tell you what the intent was. She's evil. She's diabolical. Some say, okay, her intent was to get the money and be with Chad. Yeah, but folks, ultimately, it really is under this black-ass umbrella of evilness and her stupid, narcissistic crap. So, yeah, motive, opportunity, intent are permitted uses for 404B in Arizona. And you have the state must make disclosure to the defendant as to such acts as required by Rule 15.1, Rules of Criminal Procedure, no later than 45 days before the final trial setting or at such later time as the court may allow for good cause. So Lori's going to know whether they're going to use 404A, B, or C. And I'm not even going to go into 404C because that's character evidence in sexual misconduct cases. So that wouldn't apply at all, even though this hussy was nothing more than a slimy-ass hooker. And it was all about using her damn body to get her way. She was a seductress, clear and simple. But it says, a notice in a criminal case, they're going to have to let Lori know about that. Articulate in the disclosure the permitted purpose for which the state intends to offer the evidence and the reasoning that supports the purpose. The defendant must make disclosure as to rebuttal evidence pertaining to such acts as required by Rule 15.2, no later than 20 days after receipt of the state's disclosure or at such other time as the court may allow for good cause. In other words, when the state, if they use 404B of her, all that stuff in Idaho, and I do believe that this judge will probably narrow that, just as Judge Boyce did as well. But I think there's a big possibility that 404B will be used. She's going to know what they're wanting to do it for, the purpose, and then she has to come up with something to rebut that. She better put her big girl panties on. You know, the ones that are all crusty and green, slimy, nasty. But, it is what it is. Mark McGarry says, I would forecast yes, likely by the state. Yeah, the actions in the timeline. Tina Reddington says, Mark, do you really think he's going to testify? I'm not sure. She would call him. Oh, Lord, who are we calling for Charles Vallow's sons? Well, I'll tell you, if she did decide to do that, she just wants to cause everyone as much pain as possible. That's what she wants. She just wants to twist that knife just a little bit more. What is upsetting to me, y'all? What is upsetting is if the state of Arizona needs Kay, Larry, or any of the victims' family members to testify, which they will, y'all, and she gets to get up there and ask them questions, I'd beat her damn ass. She better be respectful in front of those jurors and that judge. Because I'm telling you, it's disgusting. It's disgusting that this woman wants to do this. She wants to blame Tylee. She wants to hurt her son, Kobe, more than anything on a freaking telephone call. She could have just said, I'm not going to talk about it, Kobe, which would have been a hurt for him anyway, because I know he wants answers. But no, she had to make sure that it's all about hurting as much innocent people as she possibly can. And she is absolutely looking forward to having any of those victims' family members on the stand. And I just cannot believe, y'all, that she's going through with this. I don't think she's going to take it all the way through the whole trial. I just don't believe it. And I didn't believe she'd even go pro se, so I'm probably sitting here all wrong. But I will say this, she's filed this motion. She's starting down this road. She's got, 6 months. June is the court. It could be put off a little bit longer. Because she is pro se, I don't know. She could put in a motion to continue. She could do all kinds of stuff. But, bottom line is y'all, she's going to be examining people. So, oh, hey. Will you hand him here? Yeah. All right, y'all, there's somebody I want you to see. Now, Opie's going to take questions. Opie, I need you to take questions to all the Rays out there. Opie, Opie boy, Opie. Look at him, y'all. Look. He thinks I'm a nut, y'all. All right, y'all leave your comments on the rewatch, and I'm telling you what, I'm up to bat on this dang hussy dang representing herself. We're going to talk about things that we thought we already knew about the judicial process. Justice through understanding means a lot of different things to a lot of different people, and I've got the best of all the Rays and all the wonderful people on this channel to help me get a little justice through understanding. So leave your comments on the rewatch. Maybe there was something I missed, or something you want to teach me, something you want to tell me that I can go look and find out about, and we'll keep on keeping on. If y'all are willing, I'm here. Thank y'all so much. And by the way, Christmas Eve, there's a few people that are going to be on their own Christmas Eve, and OKJ's going to try to bring a little smile to your face on Christmas Eve, just like I have every year. So just be looking for that announcement for Christmas Eve. And I love you all. Thank y'all so much for all the support with Wayne. His appointment went really well with his surgeon. He's allowed him to drive now. He's just doing incredible. And he'll find out after February whether he can go ahead and go to his therapist. Right now, he's doing in-home exercises. He's having a great, everything's going good. The only thing is he has to sleep on his back for now. And when he sleeps on his back, he snores. So him and I, since his surgery, have not slept in the same bed together, which is damn, I just don't feel good without him with me. But I can't sleep when he snores. So Say a prayer for us that he can get back on the, horse again. And us get back, to things being a little bit normal. And I love you all. Thank y'all for being here. And we'll get back together soon and keep on looking.